Some people turn to Ncat because they believe a New South Wales government agency has made a decision that affects them that is wrong. In the scenario that follows, Fadi, a taxi driver, believes that Roads and Maritime Services unfairly cancelled his authority to drive a taxi after some passengers complained they'd been charged too much for their taxi trip. Here's how the case unfolded. Fadi had been driving taxis in Sydney for 5 years. A few months ago, Roads and Maritime Services told Fadi that he could no longer drive a taxi because passengers had complained that they had been overcharged. When they asked Fadi about these incidents, he said he had not been driving his taxi on those dates, so it could not have been him. Nonetheless, Roads and Maritime Services said that because of the evidence given to them by the passengers, they were cancelling his authority to drive a taxi. Fadi was told this in a letter. The letter said that if he was unhappy with the decision, he could apply to Ncat within 28 days for a review of the decision. The letter also said that the decision would take effect immediately, and if Fadi wanted to keep driving a taxi, he would have to apply for a stay of the decision. A stay means that the decision is put on hold until the tribunal makes its final decision. This requires a separate application. Naturally, Fadi was very unhappy with this decision. Driving a taxi was the way he made a living, and without it, he would not be able to provide for his family. He felt that RMS's decision was wrong and that he would find it hard to get another job because his English was not very good. Knowing that he would have to speak about his case in front of the tribunal, Fadi had to decide if he wanted a lawyer or agent to help him. Fadi didn't feel he had enough money to pay for a lawyer, so chose to phone Law Access for free legal information instead. To have his case heard at Ncat, Fadi had to fill in an application form from the tribunal's website. Following the website's instructions, he then had to make 2 copies of the application and the letter from RMS. Fadi posted the application with a cheque for the filing fee to the Ncat registry. He also filled out an application for a stay so he could keep driving his taxi until a final decision was made about his case. Fadi was not able to drive his taxi while he waited to hear back from the tribunal about the stay. Fadi soon received a letter telling him that a date for his stay hearing had been set. The tribunal's letter also said 2 other things. First, it told him that Ncat had sent his application to RMS. Second, it asked if Fadi would need any extra help with the hearing because of a physical disability or problems with English, for example. The letter said that Fadi should let the tribunal know if he needed this kind of help. In the meantime, the tribunal ordered RMS to provide all of its documents that related to Fadi's case and to explain why they had made the decision to cancel his taxi licence. Fadi wrote a statement that said the reasons why he should be allowed to continue to drive until the tribunal made a decision. He sent the statement to the tribunal and to RMS. At the stay hearing, the tribunal member listened to Fadi and to a lawyer from RMS. The tribunal member considered all the relevant information, including the problems it would cause for Fadi if a stay was not given and whether it was in the public interest for him to continue to drive. The tribunal member decided that Fadi could continue to drive until a final decision was made. The tribunal also made the following orders. RMS had to send to Ncat and to give Fadi any of the Section 58 documents that were not yet provided. Fadi had to send to Ncat and give to RMS any relevant documents that he had not already provided. These documents could include character references or statements from people who could say where Fadi was at the times when passengers said they had been overcharged. RMS had to provide any documents in reply to Fadi's documents by a certain date. The tribunal member also told Fadi the date of his hearing and that it would probably take half a day. The members said that the location of the hearing could be a regional area if that was the most convenient for the parties and witnesses. When he received copies of the documents provided by RMS, Fadi made sure he read over them very carefully so he could properly understand the case that RMS would put forward at the hearing. He decided to call Law Access to get information to help him prepare for the hearing. Fadi knew from the letter and what the member told him at the stay hearing that the legal test that the tribunal would use in his case was whether he was a fit and proper person to have a taxi licence. The tribunal member had also told him to think about what evidence he could provide to help his case. This could include witness statements, character references or medical reports if they were relevant to his fitness to drive a taxi. Fadi knew that he could only use the documents that were provided to the tribunal and given to RMS before the hearing. Fadi understood that he had to provide these documents by the date given at the stay hearing. When the day of the hearing arrived, Fadi was very nervous. He didn't want to lose his right to drive a taxi and was worried about his ability to argue his case well enough to convince the tribunal to overturn RMS's decision. When he arrived at the tribunal 15 minutes before his hearing, the first thing Fadi did was to check the list to see what hearing room his case would be heard in. When Fadi arrived at the hearing room, the member of the tribunal who would hear the case introduced herself. The member asked Fadi to sit at the long table opposite her next to the person from RMS. There were 3 people sitting at the back of the room. One was a passenger who said Fadi had overcharged him. The member explained that the hearing would be sound recorded. She asked Fadi to call her Ms. Bradbury and to call the lawyer from RMS Mr. Oliver. The lawyer from RMS explained that RMS had cancelled Fadi's taxi's licence because he had overcharged passengers. RMS then asked one of Fadi's passengers to answer questions in front of Miss Bradbury. The passenger confirmed that Fadi was the driver who overcharged him. The tribunal member then asked Fadi if he would like to ask the passenger any questions. This is called cross-examining a witness. Cross-examination means asking the witness questions about their statement. After a short break, it was time for Fadi to tell his side of the story. He didn't have any witnesses, but had already handed in a statement from his wife saying that Fadi had been home with her on the days the passengers said they were overcharged. The lawyer from RMS was then able to cross-examine Fadi with questions, which Fadi answered. Once all the evidence had been presented, both Fadi and the lawyer from RMS were given the chance to make submissions. Submissions are arguments about the meaning of the legal test, which in this case was what fit and proper person means, and whether the evidence showed that Fadi was in fact a fit and proper person or not. RMS argued that Fadi was not a fit and proper person to hold a taxi licence because he had deliberately overcharged passengers for his own personal gain and then lied about it. Fadi said that he had done nothing wrong and that because he did not do what RMS said he did, he should be considered a fit and proper person to drive a taxi. Sometimes the tribunal member will make a decision about the case at the end of the hearing and give the reasons at that time. In Fadi's case, the member said she would need to think about all the evidence and then write down her decision. In the meantime, Fadi could keep driving his taxi because a stay had previously been made. The member explained that the decision would be either that RMS made the correct decision in cancelling Fadi's taxi licence, or that RMS did not make the correct decision and that Fadi's licence would be given back. Lastly, the member explained that the tribunal's registry would contact both parties by phone the day before the decision was due to be published on the internet. She said that no one would need to come to the tribunal because a copy would be posted to both parties and then published on the case law website. Do you feel like a wrong decision has been made against you by a New South Wales government agency? You can find out more by visiting the Ncat website at www.ncat.nsw.gov.au.